the currency of power. And I make this submission simply because long ago it was a British Chancellor of the Exchequer, Lord Thurlow, who said, corporations have neither bodies to be punished nor souls to be condemned. They therefore do as they like. Corporation is a juristic person consisting of various shareholders. And those shareholders who are in management take a decision on behalf of other shareholders or on behalf of the juristic person that they will contribute. They will buy electoral bonds, and then they are given a further assurance that their contribution to X political party or Y political party need not be reported to anyone.
Yes.
So, if my lords then see in actual practice over the past few years what has happened, your lordships have been shown various records derived from political party statements, which have been further analyzed by the ADR. Now, my lords, my client, what he has done is, he has gone to the balance sheets of certain listed public companies. They are not before your lordship, so I am not going to mention any names. Your lordships may treat them as Corporation A, Corporation B, Corporation C. But now, please, if your lordships just turns down towards now page 6916, two or three pages before that, my lords. Now, 6915 is the corporation's statement of profit and loss. Thankfully, my lords, those documents are also highlighted at the relevant portion. Now, here, they do not even put in the profit and loss statement as they are required to under the law that they have actually bought election bonds. What is done is the next page. Other expenses. And in other expenses, right at the bottom with a double hash, it includes rent, printing, stationery, security repairs and maintenance expenses, etc. Further, it includes political contributions amounting to 273 and 412 made under 182 of the Companies Act during the year of March 31st, 2020 and 2019. Now, this is not 412 rupees. This is expressed in crores. And how do you know that? You go back, because you have to go not crores, my lords, in. Please stop. All amounts are in millions of Indian rupee except per share data. Right at the top of page 6915.
So it is 412 million rupees.
Yes, it's 41 crores. So similarly, my lords, and since your lordships, one of your lordships has penchant for figures. Yes, my lords.
6914, it's specifically miscellaneous expenses.
691.
Include donation of rupees 20 crores paid to political parties.
Yes, my lord.
Through electoral bonds.
That is another corporation, my lords. Each of the corporations there are no fixed standards each corporation puts it somewhere or the other. Some include it with rent, stationery, and the rest. Sometimes it's said that the truth in affidavits, what is revealed is interesting, but what is concealed is vital.
That's how the accounting treatment takes place in the corporation. Yes.
Please, my lords. So
That's the
now what,
accounting system. That's the accounting.
what is it which is actually required, my lords?
What is
And,
the submission? Mr.
if you
Heggde
look-
now, what's the submission?
My lords, the submission is this, that even under the current law, at page 8 of the same volume, Mr. Prashant Bhushan's chart, what is required is that no such contribution shall be made by a company unless a resolution authorizing the making of such contribution is passed at a meeting of the directors, and such resolution shall, subject to the other provisions, be deemed to be justification in law. Each time that there is a purchase of an electoral bond by a company, there has to be a resolution of the board of directors, which is not normally open to the public. They are not, the company maintains minutes books. It is available for inspection. Each of these resolutions, my lords, because these electoral bonds are election specific. It can't be.
No. It's the bonds are sold at certain specific stipulated times in a year. January, April,
No.
October, and then 30 days for the general election.
My lords, it is whenever there is an election
The argument of Mr. Sibal is that it's not election related at all. Because when you purchase the electoral bond in, say, January, there may not be an election on the anvil at that point of time at all.
my lords,
And you have to expend it within 15 days. Otherwise, it ceases to be valid in the sense that the contributions made to the PM's relief fund.
it has to be cashed within 15 days.
Otherwise, it's
So
a
therefore,
service purpose.
the political party can take it into its accounts. As to when the political party uses the money, there is no limit on that.
That is what Mr. Sibal is arguing, that it can be used for any purpose.
Any purpose at
It
all.
can be used for any purpose. You create an office, a huge political party office. You have residences there for the party leaders. That is sanctioned, and it can be
Therefore, he
done
said
at
that
any point of time.
he said that the term electoral bond is a misnomer.
You can purchase an aircraft or a yacht.
Yes. But the point here is, my lords, this tranche, each tranche of issue of electoral bonds is normally linked, subject to correction, my lords, so your lordships can clarify it with the declaration of elections.
It's not available throughout the year. There are specific times.
Specific times. Those times are often matched.
No. The specific months in a year, I think there are four months,
Quarters.
4 quarterly.
Quarter.
It also happens, my lords, that almost every quarter there is an election.
No, it's not necessary.
And not
It-
a state or a,
No, it may be a bipole or something, but not every general election doesn't have to.
not a general
four
election,
times
not
a
a
year.
general election, not a general election. But every few months, there is a series of elections. And around that time,
Mr. Sibal is nodding in no, and his experience is greater than yours, at least in that.
that I concede. That I concede. My lords, my respectful point is this, that even with the changes in law, there are compliances required, and those compliances can be further enhanced by what your lordships, the Chief Justice referred to, as far as the Election Commission is concerned. There is the Election Commission notification under 324, with regard to electoral trust. I would, Mr. Hansaria said that it was not on the website. Thanks to Mr. Prasanna here, I could get it retrieved. If your lordships kindly sees what the election in trust notification
thing,
itself said.
Just one thing.
Please, Malik.
We take it, all of you, the way you've argued, is the relief you're seeking is quashment of the scheme itself, complete scheme.
Yes, my lords,
Not any part of the scheme. Not any portions of the scheme. Or
No,
you are
we-
seeking is erasing of the scheme with regard to anonymity.
my
And the
lords,
challenge to the validity of the amendments to the law.
it is a challenge
Let's
to the
face it,
validity
you
of
have
the
not-
amendments.
none of
I am
you
not.
have till now been very specific on that. You have broadly argued, but on the question of relief or the prayer you're seeking, what do you?
My lords, I am an intervener. I can't.
You're right.
I can't.
You're right. You're
go
right.
ahead.
It's a wrong question to you.
Yes, my lord.
We are seeking that the entire scheme be set aside as arbitrary.
Okay.
And the
One of the
amendments.
elements of arbitrariness is obscurity. That's one of the elements. There are other.
We're not asking,
argued.
we just,
Since your lordships put it like that, one of the elements is that, but well, it's much broader than that, which is what we want.
As an intervener, all that I can point out is
You're supporting the petition.
I support the petitioner, and I'm making a further case that even under the law as it currently stands, your lordships can impose further directions which would possibly reduce the opacity.
Thank you, Mr. Agde. Thank you.
Would your lordships kindly allow me to place that one election commission document?
324.
Yes,
Please, my lords. Under
we
324.
are uploading it? All right.
Yes, my lords. It has been uploaded.
Let's see that.
Please, my lords. This was with regard to electoral trust. It has been. Prasanna will have. It's out here. As per Rule 17C(a) of the Income Tax Rules, the electoral trust can receive voluntary contribution from any company or individual for funding of political parties. Under the existing law, for transparency of funding, political parties are required to submit their contribution reports in excess of 20,000 from any person. However, there is no such transparency requirement either regarding source of funding or dispersal of funds to political parties through electoral trusts. Therefore, there is a legal vacuum in respect of disclosure of contribution reports by electoral trusts. In exercise of the plenary powers vested in it by virtue of Article 324 and all other powers enabling in this behalf, the Commission hereby issues the following instructions. Electoral trusts are required to submit an annual report of contributions to the Commission before the due date of filing of the income tax return. The report shall be in the enclosed format. The report shall contain details of contributions received from any person or entity, details of all donations given to political parties in a financial year as per the format, and the format specifies the period and the specificity. The annual report shall be verified, signed by the person authorized, and a copy of the. And if your lordships was speaking of the Satya Electoral Trust ballots, that the list of approved trusts was there. And then, my lords, the abstract of donations, details of the contributions, and Part C, name of the political party, PAN, amount distributed, date, and mode. So it's not as if, even under the existing law, the opacity cannot be reduced. I'm grateful.
Thank you, Mr. Agde. Yes.
This document is there, no? Page 7305, volume 4.
Volume 4, page 7305. Thank you.
It's my learned commission again.
Maybe we'll put that. Go.
My lords, I appear on behalf of Dalit Panthers Party, my lords. My written submissions are at page 182 of volume 1. What you may kindly have it. Page 182 of volume 1. My IA number is 156371 of 22. 156371 of 22 minutes. $182 minutes.
Yes.
My lords, my submission is threefold. My lords, the first submission is, my lords, we represent a political party, which, my lords, in fact, the political party for a change is on the side of the petitioners, challenging the scheme, the electoral scheme or the secret bond, as we call it from our side. Now, my lords, the issue here is, as a political party which espouses the cause of Dalits and other marginalized people, but this scheme is in such a way it's structured that it has a desperate and a more severe effect on us than other political parties. So that way, my lords, there is a very hostile discrimination as far as our parties are concerned, which expose the cause of these marginalized sections for two reasons. And this court has held, my lord, this is what precisely has to be avoided in any scheme or in any law.
Yes.
Well, the first point is, if your lordship would see, my lords, clause 3.3 of the scheme, if I may call it as clause 3.3 or rule 3.3 of the scheme, there is a cap of 1% of the electorate. It says, my lords, only the political parties registered under section 29A of the Representation of People Act and secured not less than 1% of the votes polled in the last general election to the House of the People or the Legislative Assembly, as the case may be, shall be eligible to receive the bond. Well, the point here is, when you make a discrimination between 1% and the other 99%, there is absolutely no rational nexus.
There is
Because
a rational nexus. A political party should have polled at least 1% of the votes in the election. Tomorrow you may have a 2% party and claim donation.
well, this is our case, there is a barrier to entry. And nascent political parties, my lords, in a free and fair election, the receipt of political donations cannot be cut. My lords, for example, I start a political party.
You can receive donations, but you can't have electoral bonds coming.
Well,
And the exemption.
that's precisely my lord, that is where I stand at a disadvantages. When people don't come out, my lords, to give monies to political parties on the basis of their ideology, people will definitely not come to me, my lords, on the basis of my ideology, because they want to be anonymous. The very purpose of what the state says today is anonymity is given for the purpose of protecting the people who give these bonds. And when that anonymity is taken away, my lords, my point is that it affects me directly. That same anonymity would apply to me.
Because, even other political parties, it's not that, only a political party like yours espouses the cause of the marginalized section.
Not really.
There would be mainstream political parties which equally espouse the cause of the marginalized groups because they depend upon them as their constituents.
My lords, we are next. The point is, my lords, that where anonymity is given to all political parties, I should be given the same anonymity in the sense that I am also a political party registered under the Representation of People Act. Why not 5%? Why not 10%? There is absolutely no empirical data to suggest why you have protected under 1%. The whole point is, my lords, when anonymity is given to all political parties under a statutory enactment.
But then you also have threshold requirements for allotment of an election symbol.
It should be supported by data, my lords. There's absolutely no data. For example, it's 0.99%.
That you made your point. What's the next point now?
That's one point. My lords, the second issue, my lords, is that if your lordship may kindly see the issuing at Rule 3.6, my lords. Rule 3.6. The bond shall be issued to the buyer on a refundable basis.
There's no Rule 3.6. No para 3.6.
My lords, it's sorry, my lords, 8.2, my lords. I'm sorry. Yes, no, it is 6.66, my lords. It's 6.6.
No, there is no 6.6. You may be referring to 7.6.
It is 7/6.
Volume
Yes,
4, page
it's 7/6.
119.
Yes, my lord, 7/6. The bond shall be issued to the buyer on a non-refundable basis. These are irrevocable bonds. So even by lots, even by mistake, the whole point is read with 10. 10 talks about issuing officers and commission payable. No commission, brokerage or any other charges for issue of the bond shall be payable by the buyer against purchaser of the bond. Now, this is taxpayers' money. For example, my lords, if myself or anybody else here wants to buy even a demand draft or a promise or anything else, my lords, there is a charge which is borne by the customer. Here, the customer bears the charges of a note which is being given actually free of cost.
But
So,
the
my
best
lords,
point,
these
you know,
are
I don't think we need to labor on these points.
these are all, my lords, things which have been tightened
These
to
lie
ensure
in the
to
realm of
facilitate.
policy. These lie in the realm of policy. These are not the best points. I mean, let's
My lords,
not.
your lordship may kindly see, my
We are
lords.
missing the wood for the trees
My
by
lords, if your
focusing.
lordship may kindly see them at page 1115, my lords, volume 4.
Substantive arguments have been made.
1115, my lords. Your
Let's
lordship
not
may kindly
dilute the
see.
impact of those arguments by going into these.
My lord, 1113, my lords. Your lordship may kindly see 1113. 1113 for disparate impact. 1113, volume 4. My lords, here, your lordship, under 182, it is the corporate boards which take a decision. And as well as these, we are concerned, our, my lords, the empirical data suggests that we control only 3% of the boards in India. That is in respect of 1,000 top companies which are registered in the stock exchange, Bombay Stock Exchange, as well as the National Stock Exchange, where the market capitalization is 1/4. The Dalits and the other marginalized have only 3%.
We are not belittling your grievance. But your grievance is a wider systemic grievance, which is not particularly related to electoral bond.
My lords,
So your grievance really has to be in the form of another petition, which challenges broader aspects of our election law, which have a disparate impact on parties espousing the cause of the marginalized. But by really conflating that grievance with the challenge to the electoral bond, we are really losing sight of the specific challenge in relation to the electoral bonds. You may want to come forth with a petition, a broader petition challenging those provisions of the election law, which may have possibly a disparate impact on parties, say, espousing the cause of the Bahujan parties. We're not at all belittling that, but we're just trying to say that let's not lose the focus of this challenge.
This aggravates the inequalities, my lords. My point is,
Right.
schemes after schemes like this. My lords, today, my lords, my position is, if I am a nascent party.
We don't want to say in this petition, assuming that the others are right, that you have not made out your cause, because that may lead to your cause in that sense being impacted by us ruling on this in a petition where, you know, we don't have the sufficient data. We
Then
don't
your lordship may
have
kindly
the
see.
overview of our election law. So you are raising a point relating to the marginalized groups, but please keep your powder dry for a substantive challenge in a separate petition. That's what we are trying to just sort of without advising you. But you know,
I
you
follow.
don't want to lose the impact of what you are saying in a more specific challenge. This is a very niche challenge in that sense. Very important challenge, but a niche challenge.
Then my ground on 19-1A, my lords, is slightly different. If your lordship may kindly look at my notes, my lords, my 19-1A challenge is that at page 180, at page 187, my lords, that the right to know rival political parties' funding sources is also a part of a political party's right here. But one is for the right of one is for the voter to know, because one is for the voter to know as to who is funding whom as a right of information.
Republican Party, they are not.
Who bankrolls the rival parties? Well, the position here is, your lordship may kindly see, visualize the position that our parties are in at this stage. Now, bigger parties, because of the money and power play methods, become bigger and bigger. We become smaller and smaller. There are barriers at the entry.
That's not an issue here.
My lords, that's precisely, my lords. Therefore, at least on 19-1A.
Totally going away from the main issue.
My lords, on 19-1A, my lords, in which case, my lords, I'm not pressing that point, at least on 19-1A, the political party's rights to know rival political parties' funding is.
So, you know, the problem is that you are an intervener. You have not filed a substantive petition. Therefore, we can't strike it down on the ground which you are asserting. You can only support the cause of the petitioners and the main
This is
petition.
apart from my
So
lords.
therefore, you know, you may want to perhaps reassess your position, come to the court or an appropriate high court and challenge specific provisions of the law, election law, which according to you have a disparate impact on the parties which are representing the Bahujan causes. I mean, we're not at all saying that you're not right on your broader grievance. That will have to be examined by a constitutional court. But you may want to perhaps frame it very differently. Why get into it here as an intervener without adequate data, without adequate challenges to other provisions of the law?
That's
the
apart
thing.
from, well, that's in which case, well, that's the other point. On 19
We will not say anything which will affect your cause. Please rest assured. But we are also trying to tell you that perhaps
Your lordship may kindly, then lordship may kindly say that these will leave another day for this cause to be agitated, my lord. It's not that your lordship has heard
You're an
it.
intervener.
you are an
No, my lords, the
intervener.
point is, my
You
lords,
can never affect your rights.
no, my lords, the point is, at least then, my lords, under 19(1)(a), my lords, I should at least know the critiques of these parties, as far as who is bankrolling, that right to information about political parties being funded.
That Mr. Bhushan argued, Mr. Sibil argued, everybody has argued that. That there is no difficulty. Now that has been argued. That point you join with the others.
Yes, apart from my lords, adopting all this one, my lord, the thing is, just one paragraph of the
I
judgment.
think we'll now conclude
My
your
lords, only one paragraph of the judgment, my lords, and then I'll leave it to your lord.
one paragraph of the
My lords, page 1804, my lords.
one para of what are you reading?
My lord, 4204 of Kanwarlal Gupta, my lord, Justice Bhagwati speaking, as far as this party regarding elections and the expenditure and what are the other parties' role. Just 10 lines on that.
Kanwarlal has been cited yesterday.
This one paragraph have not been said. 10 lines, 2 minutes,
All
my lord.
right.
Your
Tell
lord
us.
may kindly see, my lord. This is, my lords, 1975 3 SCC 696 at page, my lords, I am reading 4204,
Volume.
volume 4, my lords.
Volume 5, no? Page?
Volume 5, my lords, sorry, I'm volume 5.
Go to
Volume 5, my lords, 4204. That's 10 lines from top. Or 10 lines from bottom, my lords. The object of the provision, your lordship got 10 lines from bottom. The object of the provision limiting
expenditure is twofold.
yes, ma'am. It's not my this one. Lordship, may I have a look at it? Sorry, my lords, extremely sorry. Yeah, the object of the
Much
provision
higher.
limiting the amount far in excess of the limit. The object of the provision limiting the
We've seen
expenditure is
it. Yes, you
twofold.
got the point.
That's
That is
precisely
the-
what. So this directly impacts us, my lords, in a way.
Thank
Therefore,
you.
my lord, that
Thank you
would be
so much.
considered.
Thank you. Mr. Attention.
What about division of?
Shall I make one short submission?
Mr.
I
Raj,
won't be,
now
I won't be making an,
get to the Attorney General's arguments now. Everybody can supplement what they want to say in a small note or something. You have given your note, Mr. Kaliswaram Raj?
yes, I have given it,
Get your
I
note.
have given it,
Yes,
yes.
yes, Mr. Attorney General.
We have a division of labor.
Yes.
So on the contours of the scheme, the learned solicitor had gone certain submission. But on larger questions of 19(1)(a), the connection, confidence, etc. That's how we have proposed to divide our labor. So let the solicitor begin on this preliminary submission. Yeah.
May it please, Your Lordship. Lord, at the outset, Lord, as my Lord, the Chief Justice and the bench yesterday answer, I thought Your Lordships are rising. Lord, no, somebody came, so I thought Your Lordships are rising.
Start afresh at 2 o'clock.
I can start at 2, my lord. It's,
It's just one thing, you see, there's one a larger issue which we are not really
Lordship.
examining, that is of election funding, because
Yes.
that's the second issue which arises, but it dovetails into this issue, is with regard to the corporate funding. And whether it should be open, transparent, or whether it should be. Now, other issue which arises is they have referred to the kickbacks and the bribes and other things, or quid pro quo. Now, there can be various terms used for that. We like the election commission if they are aware of the total financing which is required for each general election or for the state elections. On an average, state elections will be an average, an amount which is collected and used through these bonds. The issue which may come up is, because we have this opacity with regard to who's funding, etc., then how, if there is any quid pro quo, how does anybody establish it?
we have an answer, first of all.
That-
I'll answer that, but please do not bear one thing in mind. Please, for the time being, for appreciating my arguments, remove the two expressions repeatedly used, anonymity and opacity. It is a restricted, limited confidentiality which can be, my lord, opened and the veil can be lifted by judicial direction. I'll point that out.
Thanks. We'll resume after lunch.